Thank you. Thank you, Priya, very much. Priya's with our Bureau of Justice Assistance, works on the right to counsel work. Also, Maha, thank you for your good work at Access to Justice, also putting this program together today, and we're certainly very proud to host it. Also want to thank the Deputy Attorney General for being here with us. I'll introduce him in a moment. But also want to thank American University's Justice Programs Office for their work with us, and of course, each one of you for being here. Your commitment not only to this issue, but also to this consortium, and your attendance here today is vital to our work in this area. DOJ, I hope you feel, is firmly committed to the principle of effective assistance of counsel, and I think this is indicated by the Deputy Attorney General's presence here today, and also I know the Attorney General's personal commitment to this issue as well. We seek to uphold the rule of law while also maintaining a justice system that is equitable and accessible. The Gideon decision was handed down unanimously by the Supreme Court back in 1963, and it found the Sixth Amendment right to counsel pertained to all criminal defendants across the country, whether in the federal or state system. We have what at the time was a very unique constitutional system with bedrock principles to ensure fairness, such as protection from improper search and seizure, as well as the right to confront witnesses and to have a trial by a jury of your peers. And these are all incredible rights that, at least at the time, were, I think, unique to the American experience, and now most countries around the world also provide. However, I think we all know that those rights don't mean anything if you don't have effective assistance of counsel to ensure that those are properly raised during the course of a criminal defendant's time in the criminal justice system. And that's where your work is so important. We're 54 years in to the constitutional right to counsel, and we've made great progress. We've enjoyed many successes, but there's also much work left to do. And that's where all of you come in and your good work. So we thank you for your commitment to the issue, and we plan to continue to work with you here at the Bureau of Justice Assistance, the Office of Justice Programs, and the Department of Justice. Now it is my great honor to introduce our keynote speaker today, our Deputy Attorney General. Deputy Attorney General Rod Rosenstein has enjoyed a long and distinguished career here at the department, and yet he's quite young. So, but he has done a number of things. Among his professional accomplishments include being a part of the AG's honors program. He worked in the public integrity section here at DOJ in the 1990s. He was the head of DOJ's tax division and served for 12 years as the U.S. Attorney in the District of Maryland, which is no small accomplishment, and accomplished great things there, such that he immediately came to the AG's attention once he was set. So Attorney General Sessions reached out to Deputy Attorney General Rosenstein and asked him to serve as Deputy Attorney General. He, of course, agreed and was confirmed by the Senate on April 25. So please join me in warmly welcoming our honored guest, Attorney General Rod Rosenstein.
Thank you, Alan, for the relatively brief introduction, which I appreciated, and the compliment on my relative youth. Although you cannot spend 28 years in law enforcement and still be young, but you can still feel young. But I'm really honored to be here with so many friends in this terrific facility. We're just a few blocks from the Department of Justice, but this building, which houses OJP, is a terrific place to work and a terrific place for meetings like this one. And the technology works too. It's really an honor for me to be here. I'm grateful to OJP, to the Bureau of Justice Assistance, and to our Office for Access to Justice for helping us to focus on the right to counsel in the United States. I'm so pleased also that we're hosting the meeting here at OJP's building in the Department of Justice. Our most fundamental mission is to seek justice and to protect the American people by enforcing the rule of law. Now, that can only be done if we honor the rights of the accused. The right to counsel, as Alan mentioned, is enshrined in our Constitution. It's founded in the Sixth Amendment, which provides that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. It's written in the Constitution, but as Alan said, it wasn't always interpreted to be a right that has to be provided by the government. But our founders understood the necessity of protecting individual rights from government overreach. And no clearer overreach exists than the power to take away someone's liberty without due process of law. Protecting the right to counsel is a fundamental component of preserving the rule of law and ensuring that everyone has the right to counsel. The point of the rule of law is to maintain a fair and rational system of justice characterized by universality. What do we mean by that? What we mean by that is it applies equally to every person. Under the rule of law, people who are tasked with enforcing the laws need to do it impartially. And a fair and strong criminal justice system requires a robust adversarial system, one that ensures that individuals who are charged with a crime have their rights safeguarded. And chief among these is the right to counsel. The case that Alan made reference to, which most of you are familiar with, Gideon v. Wainwright, in that case, the Supreme Court said, in our adversary system of criminal justice, any person hailed into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. So ensuring that individuals who cannot afford an attorney have access to effective representation when their liberty is threatened is the hallmark of a just society. As Alan mentioned, we serve as a model for the world in providing those rights. Our commitment to defending the rights of the accused is a commitment to individual liberty and part of our commitment to the rule of law. That commitment is as important for juveniles as it is for adults. And that's why it's particularly meaningful that we meet today during the 50th anniversary of another Supreme Court case, the decision in re Galt. The Galt case began with a lewd phone call allegedly placed by a 15-year-old boy named Jerry Galt. After receiving a complaint from Jerry's neighbor, the police detained Jerry and they housed him at a detention center. Later, during a hearing at which Jerry had no attorney, the judge declared that he was a juvenile delinquent and committed him to the state industrial school where Jerry could possibly remain until age 21. He was only 15 at the time. Now, the Supreme Court recognized that children should also receive due process protections, chief among them the right to counsel. Justice Fortas, in his opinion, stated that children in detention proceedings were subjected to a loss of their liberty. But at the time, children did not have the right to assistance of counsel to help them cope with the legal system. The Galt opinion acknowledges just how central the right to counsel is. So without a lawyer's representation, how can we be sure that a defendant's rights will be protected? The Supreme Court ruled that children must benefit from the guiding hand of counsel at every step of the proceeding. And all of us assembled here today, judges, prosecutors, law enforcement officials, community stakeholders, and defense lawyers, we know how true that really is, how critical it is to have effective representation in order for the system to work properly. As a former prosecutor, I saw that regularly in my work. I've seen firsthand the importance of a strong advocate on the defense side of the table. Defense attorneys work closely with their clients at every stage of the proceedings, and through their advocacy, they play a critical role, a role that is essential to our concept of liberty and due process. A defense attorney's job is not just about defending the individual client in the courtroom. Rather, that work is an integral part of the overall effectiveness of our constitutional system. The right to counsel is both substantive and procedural. A lawyer represents a client's substantive interests while simultaneously ensuring that his procedural rights are respected. A defense attorney is the ultimate check on a prosecutor's discretion and a bulwark against the wrongful incarceration of innocent persons. So as a member of the Department of Justice now for 27 years and a former prosecutor, I have always been proud of the work that our federal public defenders do. And I'm also familiar with the great work of our state public defenders. I think Paul DeWolf, who is our state public defender in Maryland, is scheduled to be here. I don't think he's made it yet this morning, but when he gets here, tell him I asked about him. Paul's a tremendous advocate for the right to counsel and has devoted his career to ensuring that defendants in Maryland courts receive appropriate representation. And one of our nation's great attorneys general is Robert Jackson. Robert Jackson's known for many things. He's a prosecutor at Nuremberg, a Supreme Court justice. Prior to that, he was the Attorney General of the United States. And in 1940, he delivered a renowned speech at the Great Hall of the Justice Department to United States attorneys. And Jackson, in his speech, he said that a prosecutor should play fair and follow the rules. Now, those provisos are obvious, but Jackson also remarked that prosecutors should temper zeal with kindness, serve the law rather than factional purposes, and approach their task with humility. A prosecutor exercises tremendous discretion. To quote Judge Richard Posner, who recently retired as a circuit judge in the Seventh Circuit, the Department of Justice wields enormous power over people's lives, much of it beyond effective judicial or political review. With power comes responsibility, moral if not legal, for its prudent and restrained exercise. And responsibility implies knowledge, experience, and sound judgment, not just good faith. Or in a remark attributed variously to Voltaire, or for members of my generation, Spider-Man's Uncle Ben, with great power comes great responsibility. Power should be wielded in good faith and with good judgment. Judge Learned Hand said that if we are to keep our democracy, there must be one commandment: thou shalt not ration justice. So prosecutors must pursue justice, and it cannot simply be measured in terms of convictions or sentences. A prosecutor's zealousness must extend not only to advocacy, but to the pursuit of truth, which is coextensive for us with the pursuit of justice. That's our goal, that justice be rooted in truth. I could not be more proud of the work that our law enforcement officers and prosecutors do at the Department of Justice to pursue truth. And we all know that truth is not about sincerity of opinion. And many people sincerely believe things that aren't true. Truth emerges through the clash of people who are devoted to examining the evidence. It emerges through decisions by neutral judges and juries that weigh the evidence on both sides to reach their decision. And you only get to the truth if you have fair and open-minded people, and if you have a presentation of both sides. So that's why there's a constitutional right to counsel. We need advocates who are just as zealous and dogged on the other side of the table as we do on the prosecutor's side. Defense attorneys scrupulously examine each piece of evidence. They evaluate the logic applied by the government, and they carefully examine the prosecutor's decisions. So defense attorneys are our best insurance that a prosecutor's mistakes, and trust me, they will let us know when we make a mistake, they're the best insurance that our mistakes will be corrected. The prosecutors and defense attorneys may be opponents in the courtroom, but we are not enemies. The adversarial system serves justice, and the defense bar protects defendants from potential abuses of power and wrongful convictions. I never regarded defense attorneys as my enemy. Obviously, when you're in a tough trial, you have differences of opinion, you have clashes in the courtroom, but I always respected the work that our defense attorneys were doing. And being a criminal defender, I know, can be a thankless job. There are a few of you in the room. It means at times representing unpopular clients. It doesn't mean you agree or support what your client did. It means struggling to mount the best possible defense, often with the odds significantly stacked against you. You know, people often look at our conviction rates, prosecutors, and they think, well, the job must be easy because almost everybody gets convicted in federal court. Well, actually, the opposite is true. The conviction rates are high because our prosecutors exercise great care before they charge a case. And that means that if you're trying to defend one of those cases, you've got the evidence already stacked against you. And so I very much respect the work that our defense attorneys do. As our founders recognized, the role of defense attorney is essential to safeguarding our system. Consider the events surrounding the Boston Massacre in 1770. After British soldiers had fired on a group of Bostonians, killing 3 of them, John Adams famously chose to represent those soldiers. According to the future president, on the morning after the shootings, he was approached by a man who was seeking to find lawyers to represent the British captain who was alleged to have ordered the soldiers to fire on the crowd. No lawyers in town were willing to represent the captain, except for Josiah Quincy, a young man who agreed to take the case, but only if Adams would join him. So Adams agreed, and as he later recalled, he had no hesitation in answering that counsel ought to be the very last thing that an accused person should want for in a free country, should want for. In other words, an accused person should get counsel in a free country. Adams proceeded to win the acquittal of the British captain, and he later represented 8 other British soldiers who were involved in the shootings. 6 of those soldiers were acquitted, and 2 were convicted of manslaughter. And I understand the punishment at the time for manslaughter was that your thumb be branded. Not something we would consider today. That was the punishment at the time. During his famous argument for the defense, Adams observed, this is a quote that is often repeated but not always attributed to John Adams. He said, "Facts are stubborn things. And whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of facts and evidence." Facts are stubborn indeed. As I learned in the Maryland U.S. Attorney's Office, so are good defense lawyers. We all need to work to ensure that the right of counsel is safeguarded, which is why I'm excited about this event today. Shoring up this right is not just a task for defenders. It's a job for prosecutors, judges, court personnel, law enforcement officers, including my colleagues from the Prince George's County Police Department here with us this morning, and everyone who values the rule of law. When we see a breakdown in the rule of law, it should not be something that we consider tough luck for a criminal defendant. It's much worse than that. It's a breakdown for all of us if people are not properly represented. So I'm proud that the Department of Justice launched the Right to Counsel campaign. Only through working together across our criminal justice system can we ensure that individuals, even those who commit crimes, are protected. Through collaboration, we're better able to ensure that defendants' rights are protected, and we all have an important role to play in upholding this critical and necessary right. So again, I want to thank our hosts at OJP for planning this event. Thank you all for being here, and I hope you have a productive meeting. Thank you very much.